Hi, I'm Anton Arcilia, and I'm here to assist you step by step in the procedures and requirements of the Mergers and Acquisitions Office, or the MAO. The MAO is in charge of all matters pertaining to the notification and merger review of mergers and acquisitions in the Philippines. In our first module, we discussed how interested parties may apply for a PNC or a pre-notification consultation. If you missed it, I invite you to watch our video on PNCs linked to this video. For our second module, we will be discussing how to fill out a notification form. The notification form provides a framework for supplying the PCC with the information required to review a proposed merger or acquisition. The notification form may be downloaded from the PCC website. When a transaction breaches the thresholds for merger notification, it becomes a notifiable transaction. All parties to the transaction will be required to submit their notification forms to initiate PCC's merger review process. We will call these transacting parties the notifying parties. The notification form must be accomplished by the ultimate parent entities, or UPEs, of both the acquiring and acquired entities. Each UPE must submit their own notification form. The MAO requires both digital and hard copies of all submissions. Parties must submit the hard copies of their accomplished notification forms and all annexes to the PCC Records Office. The digital copies may be uploaded to the PCC's online file management system. Please coordinate with the MAO staff for more information. Parties to a transaction that meet the thresholds are required to notify the PCC within 30 days from the signing of the definitive agreement relating to the transaction. The notification period shall not begin to run if the definitive agreement is not signed. A number of transacting parties have notified the PCC on the basis of a draft definitive agreement, as this removes the initial pressure of submitting the notification form within 30 calendar days from signing. But note that the notifying parties must submit the original signed definitive agreement within 2 days from signing to enable the PCC to confirm that the transaction being reviewed or the transaction approved by the Commission is the same under the definitive agreement notified. To facilitate ease of use, hard copies must be properly labeled and tabbed per document. The appendix reference number must correspond to the section of the form being addressed. The same goes for digital submissions, so please make sure each requirement under the form is saved as a separate file and labeled accordingly. Now let's go through each section of the notification form. Have a copy of the notification form ready to help you refer to the sections more easily. Try to accomplish your own form as we go along. You may pause this video at any time so you can do this section by section. The notifying parties should indicate whether the transaction involves voting securities acquisitions, such as tender offers, third-party, and open market transactions. In such instances, the acquiring entity proposes to buy voting securities from shareholders of the acquired entity rather than from the entity itself. The notifying party must identify its role in the transaction. This defines the relationships between and among the transacting parties and sets the parameters for information that must be provided. The acquiring entity refers to the entity making the acquisition. The acquired entity or target entity refers to the entity to be merged or to the entity whose assets, voting securities, or non-corporate interests are being acquired. The notifying group, which may be the acquired or acquiring group, refers to the acquiring or acquired entities, its ultimate parent entity, and all its affiliates. For Section 1.2, notifying parties should indicate whether the acquired entity is undergoing insolvency proceedings. Input the details of the ultimate parent entity in Section 1.3. For Section 1.4, tick if it is an acquiring party, acquired party, or both. Moreover, for Section 1.5, classify the UPE if it is a corporation, natural person, or an unincorporated entity. Parties may also specify if it has a classification other than what was listed in the form. Let me further clarify the identity and role of the UPE. The ultimate parent entity, or UPE, is the juridical entity that, directly or indirectly, controls a party to the transaction and is not controlled by any other entity. Remember, while the form only requires notifying parties to identify juridical entities as the UPE, the MAU may consider natural persons as the ultimate beneficial owner or controller of the notifying group during merger review. Let's review the frequently asked questions on how to accomplish the notification form.
Can a natural person be the filing UPE?
Generally, notifying parties need to identify a juridical entity as the UPE for purposes of notification. However, when circumstances warrant, the PCC may consider the beneficial owner, who may be a natural person, as the UPE when conducting competition analysis.
Is the filing UPE required to submit documents proving that no other entity controls it?
Under the form, notifying parties are required to submit the General Information Sheet or an equivalent record of the UPE and the acquiring or acquired entity. The MAU uses the GIS to confirm if control over the said parties may be tied to an entity. The MAU is also not precluded from requiring other documents to confirm if the declared UPE is correct.
If there are multiple sellers, may the UPE of one of the sellers be authorized by the respective UPEs of the other sellers to fill out the notification form and file for and on behalf of the UPEs of such other sellers?
Generally, the MAU considers the entity exercising control over the acquired entity as the UPE. In most cases, there's only one UPE per transacting party, and multiple sellers do not equate to multiple UPEs. However, it is possible to have multiple entities that exercise joint control over the acquired entity. In such case, each UPE must accomplish its own notification form. What the UPE can do is authorize an entity within its notifying group to file the form on its behalf. What's important to remember is that the entity that directly or indirectly exercises control over the acquired entity or asset must accomplish and file the notification form. Consider a scenario where there are multiple owners for a single acquired entity, and all the owners are selling their interests. In this case, the same principle applies. The entity that exercises control over the acquired entity must accomplish the notification form. The rest of the sellers, assuming they do not exercise control over the acquired entity, do not need to separately accomplish the notification form. It does not matter that the filing UPE is not the UPE of the other sellers. In cases where there is joint control over the acquired entity, all the UPEs exercising joint control must accomplish the notification form. These entities are required to accomplish separate notification forms by virtue of the control exercised over the acquired entity. In an acquisition involving multiple acquired entities, each acquisition is considered a separate transaction for purposes of notifying the Commission. In such a case, each acquisition must be notified separately. The pre-acquisition UPEs of the acquiring and acquired entities in each transaction must file the notification. If the multiple acquired entities belong to the same notifying group and have the same UPE, the transaction may be covered by a single notification, provided the shares or assets of these entities will be acquired by the same acquiring entity. Moving on to Section 1.6, input the details of the acquiring or acquired entity if it is different from the UPE. Otherwise, tick Not Applicable.
What is the required authorization if the form is being filed on behalf of the UPE by another entity within its notifying group?
Before I answer that, let's clarify what the notifying group is. The notifying group comprises the filing ultimate parent entity and every entity directly or indirectly controlled by the filing ultimate parent entity. For merger analysis, the MAU may consider entities controlled by or under common control with the ultimate beneficial owner as part of the UPE. It is important that only authorized persons represent the notifying parties before the PCC. This facilitates ease of communication between the parties and the PCC and helps ensure the accuracy and veracity of the information submitted. In doing so, accountability throughout the process is ensured. For Section 1.7, authorization may be in the form of an original secretary certificate, special power of attorney, or their equivalent in foreign jurisdictions, naming the entity authorized to file and represent them before the PCC. To accomplish Section 1.8, input the details of the entity filing the notification form if different from the UPE. Otherwise, tick Not Applicable. For Section 1.9, tick Yes if the filing entity availed of the MAU's pre-notification consultation service and provide the dates of the PNC with MAU. While not a requirement, parties are encouraged to avail of the MAU's pre-notification consultation to learn about the merger notification and review process and gain a better understanding of the information required by the MAU. For Section 1.10, input the details of the entity to whom the official receipt of the fee payment will be issued. Parties may agree on who should pay the filing fees. Just remember that the filing fees must be paid within 10 days from the receipt of the order of payment issued by the MAU. You may coordinate with the MAU on available methods of paying the filing fees. In compliance with Sections 2.1 and 2.2, only an officer or a member of the filing UPE or its designee is qualified as a contact person to receive correspondence. An officer or member of the acquiring entity or acquired entity duly authorized by the UPE or the UPE's designee may also qualify as a contact person. For Section 2.3, please take note that if the UPE is a foreign entity, indicate the contact information of the individual located in the Philippines authorized to receive communications on behalf of said foreign UPE. The PCC allows external counsel to assist notifying parties and represent them before the PCC. For Section 2.4, indicate the names of external counsel or law firm. Counsels must also be duly authorized by the filing UPE or the designee as identified in Section 1.7. For Sections 3.1 and 3.2, provide the names, addresses, and UPEs of the acquiring and acquired entities. Accomplish the rest of Section 3 by identifying the reference number and number of pages of each appendix. All entities directly or indirectly controlled by the UPE must be included in the response to these sections, regardless of where the entities constituting the notifying group operate. Take note that entities to be disclosed under Sections 3.3 to 3.6 should not be limited to only those that are related to the transaction under review or to entities that have presence in the Philippines. For the organization chart, ensure that the diagram is legible. You may break down the organization chart into separate sections if the notifying group includes numerous entities. If you wish to clarify your answers further, you may include this in the document or the remarks section of the notification form. The nature of the transaction mainly determines the applicable thresholds for notification and the structure of ownership and control that will be assessed by the MAU during merger review. For Section 4.1, choose the type of the proposed transaction. Is it an acquisition of shares or assets, acquisition of an interest in a non-corporate entity, a merger, joint venture, or others? For Sections 4.2 and 4.3, you'll be asked about the size of the party. The size of the party pertains to the computation of the aggregate value of the assets in the Philippines, or revenues from sales in, into, or from the Philippines of the filing UPE. This must include the aggregate value of assets and revenues from sales in, into, or from the Philippines of all entities that it controls, directly and indirectly. The simplest way to determine this is to check the consolidated financial statements of the UPE. Meanwhile, for sections 4.4 through 4.19, you'll be asked about the size of the transaction. The size of the transaction pertains to the computation of the aggregate value of the assets being acquired in the Philippines, or the gross revenues generated from those assets, or from the sales in, into, or from the Philippines of the entities subject of the proposed merger, acquisition, or joint venture. The form requires the notifying parties to provide details on their assets and revenues for the determination of the threshold. Sections 4.4 to 4.9 are for acquisition of assets. Sections 4.10 to 4.13 are for acquisition of shares. Sections 4.14 to 4.17 are for acquisitions of an interest in a non-corporate entity, and sections 4.18 to 4.19 are for joint ventures. Ensure that the figures indicated here correspond to the figures reported in the financial statements submitted by the notifying parties. To learn how to compute for the requested figures, refer to the PCC's latest guidance on computing whether the transaction reaches the notification thresholds. Section 5 itemizes the information required to describe the transaction. Based on the PCC's experience, it is better to be more detailed in describing the transaction, particularly the assets or shares being acquired and the business objectives sought. For the proposed structure of ownership and control, explain how the acquiring entity will assume control over the operations of the target entity, including changes in leadership, decision-making, and management of the operations. For the description of how the operations of the filing notifying group would proceed absent the proposed transaction, notifying parties may include information on whether they will continue to pursue the transaction with different entities, acquire other assets, exit the market or restructure, or just continue business as usual. For Section 5.3, provide information on whether the transaction has been submitted for clearance by other competition authorities in other jurisdictions. The parties must declare under this section if they are required to notify the competition authorities of other jurisdictions. For Section 6 of the notification form, you will need to list and provide details about the operations of all domestic and foreign entities within the notifying group that have a Philippine nexus. Philippine nexus generally means that the foreign or domestic entity has assets in the Philippines or generates revenues from sales in, into, or from the Philippines.
How detailed should the disaggregation of products be?
Disaggregation simply means the breakdown of the information within a common category to a more detailed level that would allow the PCC to make more nuanced observations. Parties must provide a level of disaggregation for each product or service that is as detailed as practicable for such categories of products and services for each line of business. The MAU may require further breakdown to understand the products and markets better. If available, brochures should be submitted. Section 7 of the notification form is about relationships between the parties. A horizontal relationship refers to a situation where two or more persons operate as sellers or as buyers in the same market. In determining whether horizontal overlaps exist and need to be declared under items 7.1 and 7.2 of the form, the following criteria may be used as a guide. Horizontal overlaps exist if, among others, A. The notifying parties or any entity within its notifying groups is active in the same product market and same level of business, as in the case of a merger between two manufacturers, two wholesalers, or two distributors. Or B, the notifying parties or any entity within its notifying groups produces, sells, or offers products or services that may not necessarily be identical but are substitutable to some degree, whether by feature or function. Or C, the notifying parties or any entity within its notifying groups caters to and derives revenues from the same or similar set of customers. Or D, the notifying parties or any entity within its notifying groups produces, sells, offers, or imports products or services in the same geographic market. The notifying parties need not be one another's direct competitor prior to the merger to constitute a horizontal relationship. Notification should include relationships involving a firm that is a potential or emerging competitor to the firm which currently operates in the identified markets. The notifying parties may consider referring to the most recent 4-digit classification of the Harmonized Commodity Description and Coding System, or Harmonized System HS-4, or the 4-digit classification of the PSIC, or the Philippine Standard Industrial Classification, to assist them in identifying their horizontal relationships. This may assist the Commission in its initial determination of the relevant product market. On the other hand, a vertical relationship refers to a situation where an entity operates in a market that is immediately upstream or downstream of a market in which another entity operates, such that the two entities are in an actual or potential buyer-seller relationship. An example of vertically related entities would be a poultry farm and a chicken restaurant. In determining whether vertical relationships exist and need to be declared under items 7.3 to 7.5 of the form, the following criteria may be used as a guide. Vertical relationships exist if, among others, A, the parties or any entity within its notifying groups is active, potentially active, or operates at different but complementary levels of an industry supply or distribution chain, from the purchase of raw materials until end-user consumption. Or B, the upstream firm or any entity within its notifying group produces, sells, or offers products or services that are currently used or can potentially be used as inputs to the downstream firm's production. Or C, the upstream firm or any entity within its notifying group supplies products or services which the downstream firm purchases or can potentially purchase as a substitute for products or services it currently uses. Analysis of vertical relationships will be conducted regardless of the geographic area where the relationships occur, as long as any of the parties' products and/or services are produced, sold, or offered in the Philippine market. A direct supply or purchase agreement between the merging parties is not necessary to constitute a vertical relationship. If the upstream firm supplies products and services to a competitor of the downstream firm, and vice versa, the parties are still required to disclose information requested under items 7.3 to 7.5 of the form. Take this transaction for example. Google Incorporated manufactures shampoo. Ion Chemicals, on the other hand, manufactures plastic packaging specifically made for liquid soap, shampoo, and conditioner. The plastic packaging manufactured by Ion Chemicals can be used by Google Incorporated for its shampoo. The same can be used by other competing manufacturers of shampoo. In this case, we can say that there is a vertical relationship between Google Incorporated and Ion Chemicals.
But what if Ion Chemicals also made shampoo or a shampoo alternative?
If both transacting parties manufacture the same type of products, we can say there is a horizontal overlap between the parties. Even if the proposed transaction does not involve purely horizontal or vertical relationships, notifying parties must still provide all information required in Section 7.1 to 7.5. The parties may request guidance from the MAU where appropriate. Now that we've clarified horizontal and vertical relationships, let's define a few more terms. What is a relevant market? The relevant market has two dimensions: product market and geographic market. The Commission assesses market definition on a case-to-case basis. The relevant product market comprises all those goods and services that are regarded as interchangeable or substitutable by the consumer, based on the characteristics, prices, and intended use of the goods and service. On the other hand, the relevant geographic market comprises the area in which the entity concerned is involved in the supply and demand of goods and services, in which the conditions of competition are similar enough and which can be distinguished from neighboring areas because the conditions of competition are different in those areas. And lastly, what is a proposed candidate market? It is the relevant market identified by the parties during the preliminary stage of notification, which may be affected by the proposed transaction. The PCC is not bound by the proposed candidate market identified by the parties in their notification. Based on the PCC's experience, the candidate market evolves as additional information is acquired during merger review. Sections 7.1 to 7.2 refer to entities in a horizontal relationship.
Which entities should be included in the list required under Section 7.1 of the form?
For the acquiring entity, provide the specified information only for the entities within its notifying group, which operate in the same line of business with the acquired entity and the entities it controls. For the acquired entity, provide the specified information only for the acquired entity and entities it controls, which operate in the same line of business with the acquiring entity's notifying group. Notwithstanding the foregoing, MAU may nevertheless require submission of information on other entities within the acquired entity's notifying group if circumstances warrant. The parties may submit photocopies of the required documents. Documents and reports appended to the notification form must be certified true by the corporate secretary or the duly authorized custodian of such records. Please take note of formal requirements that need to be original copies. Make sure to identify and attach the documents used as basis for your responses to Section 7.1 to 7.4. The notifying parties may include a written narrative report to further explain the information declared in the form. Now, to answer Section 7.6, let's clearly define the terms prior, contemporaneous, and related acquisitions. Prior acquisitions refer to the acquisitions over the past 5 years of shares, non-corporate interests, or assets in the Philippines that generate revenues from sales into, or from the Philippines. Contemporaneous or concurrent-related acquisitions are those acquisitions that are executed around the same period as, or part and parcel of, the notified transaction. Related acquisitions are those acquisitions that are of a similar nature, for example, in the same markets or similar assets, or take into consideration the notified transaction being negotiated or executed. Examples are those between the same parties, their affiliates, successors in interests, or assigns. Section 8 of the form itemizes the documents that establish the basis of the transaction, the existence of the notifying parties, and the authorization of their representatives. The first document that the MAU checks to confirm if the transaction is subject to compulsory notification is the definitive agreement. The definitive agreement sets out the complete and final terms and conditions of a merger or acquisition, including the rights and obligations between or among the transacting parties. A definitive agreement may be in the form of a share purchase agreement, asset purchase agreement, joint venture agreement, or any other similar agreement. The inclusion of conditions which must be fulfilled by a party to make the agreement effective against a party will not negate the definitive nature of the agreement. It is normal practice for entities to commission third-party studies and surveys to check the viability of the proposed acquisition. Notifying parties are required to submit these reports under Section 8. You may have noticed that some of the documents under Section 8 are internal documents that may contain confidential information. Please note that notifying parties cannot refuse submission and disclosure of information under the form on the ground that the document or information is confidential. In other words, parties must still submit confidential documents to the PCC. The PCC is serious in its commitment to protect the confidentiality of data submitted by the parties and does not disclose confidential information to third parties except under specific circumstances under the law. In submitting confidential information, the notifying parties should clearly identify confidential business information and claim confidential treatment thereof. The parties must submit both confidential and non-confidential versions. In the non-confidential version, the parties may redact the information or provide the summary. Section 9 of the notification form asks for documents that will show the authority and commitment of parties to complete the proposed transaction.
Is it necessary for all documents executed outside the Philippines be notarized or apostilled at the time of submission to the PCC?
Yes, documents executed and certified under oath in jurisdictions outside the Philippines must be notarized and apostilled or consularized at the time of submission to the PCC. Remember that these are two separate processes that parties must undertake for documents executed and certified under oath outside the Philippines. However, the PCC may accommodate circumstances where notarization or apostillization is not available in the relevant jurisdiction where the documents are executed. In such cases, the parties must submit a certification setting forth the reason for their failure to have the documents notarized and apostilled or consularized. The certification must be accompanied by a written undertaking to submit the original notarized and apostilled or consularized documents within the period granted by the MAU. Now we're at the last section of the notification form, Section 10. The PCC publishes information on the proposed transaction at the time the Commission issues a decision. For the public's information, the PCC requires an abstract that summarizes the transaction and describes the parties and their lines of business. The acquiring entity is required under Section 10.2 to submit an abstract that does not contain confidential business information. Filling out the certification completes the notification form. The certification must, first, be signed by a general partner of the partnership, officer or director of the corporation, or if the filing entity is a natural person, by the natural person or their legal representative. Second, certify that the contents of the notification form and the annexes are true and accurate of their own personal knowledge and based on authentic records. And third, be notarized or otherwise authenticated. The person signing must possess actual authority to make the certification on behalf of the entity filing the notification. Please remember that external counsel cannot sign the certification on behalf of the notifying party. Now that we've walked you through accomplishing the notification form, let me caution you about filing incorrect or misleading information. The filing of incorrect or misleading information to the Commission is penalized under Section 29C of the Philippine Competition Act, which states, the Commission may likewise impose upon any entity fines of up to 1 million pesos where intentionally or negligently they supply incorrect or misleading information in any document, application, or other paper filed with or submitted to the Commission, or supply incorrect or misleading information in an application for a binding ruling, a proposal for a consent judgment, proceedings relating to a show cause order, or application for modification of the Commission's ruling, order, or approval, as the case may be. We hope we clarified the manner how notifying parties should fill out the notification forms for the PCC. See you again in our next module, where we will discuss the filing of notification forms. Thank you and mabuhay!